Now that you've watched the video introducing the Due Process Clause, we're gonna talk about some of the cases under it. So the first cases under the Due Process Clause mostly found that laws that states and Congress tried to pass to help workers were actually unconstitutional. So the famous case is Lochner versus New York, and this case was decided in 1905 by the Supreme Court. What happened in Lochner versus New York was that New York made a law called the Bake Shop Act, which said that bakers couldn't work more than 60 hours a week or more than 10 hours a day. The first time you violated that, you got a fine of $25, and a second violation would be a fine of $50. Lochner ran a bakery, had people work more than 60 hours a week, and he challenged the law. And what he said was, under the 14th Amendment, under the Due Process Clause, both his liberty and the workers' liberty is violated because he can't have people work 60 hours a week, and bakers aren't allowed to decide that they want to work 60 hours a week. So the Supreme Court decided the issue of whether the Bake Shop Act violated the Due Process Clause of the 14th Amendment, and in 1905, the Supreme Court said it did. So the Supreme Court struck down the New York law, and they said that people have a freedom to contract. And there's a freedom that you have to make whatever contract you want. And if you want to work 100 hours a week and you agree to that, you should be able to work 100 hours a week, and a state can't take that away from you. Since the Due Process Clause says that states can't deny life, liberty, or property without due process of law, this violates that, okay? And the court said that this is the government getting too involved because they didn't do anything to show that working more than 60 hours hurt the health of the workers, and baking isn't particularly dangerous. So the court said that if this was a more dangerous job, like working in a factory with heavy machinery, and there was something to show that the workers would really get sick if they worked more hours, then maybe it would be okay. But since baking is safe and there's nothing to show that working more than 60 hours makes you sick, a state can't do this. Otherwise, it's taking away your liberty to be able to contract. So this case, and there is several other like it, are mostly repudiated now. As you know, we do have minimum wage laws. Other cases said you're not allowed to minimum wage laws because it gets in the way of my rights to work for whatever I want. If I want to work for $1 an hour, I should be able to work for $1 an hour. And a lot of these cases, when they were repudiated, realized that it's not really so much my freedom to be able to work for $1 an hour, and having legal minimums that need to be followed in the law help workers as opposed to take away our rights. Again, you could think about this debate when you're talking about coronavirus, whether states saying employers have to close helps employees because that way their bosses can't force them to work and possibly die and infect others who would die, or takes away your right to work and get coronavirus and spread coronavirus if you want. I'll look and see the picture, and I'll post a link to it in the comments, but if the protester is holding a sign that says give me liberty or give me COVID-19, and is that a decision that employers and employees should be able to make under the 14th Amendment? But anyway, those cases that struck down these laws under the Due Process Clause have mostly been repudiated, and the court ended up changing its mind starting in the 1920s. So the 1920s cases that we have, the first one is Meyer versus the state of Nebraska, which was decided in 1923. So Nebraska made a law saying that the only language you could teach in was English. And Mr. Meyer taught at a school for people who are Lutherans, and he taught the German language. And he was convicted under the law for teaching German. And so the Supreme Court decided Nebraska violated the Due Process Clause, right, by taking away his liberty, his ability to teach German, and the students' liberty, their ability to learn German without a good enough reason. And keep in mind from the first video, we're always going to ask if the government had a good enough reason, okay? The government can put you in jail, the government can sentence you to death, the government can do basically whatever it wants to you if it has a good enough reason. So we're gonna, in all of these cases, see if the government has a good enough reason. So in this case, the Supreme Court said no, that the government didn't have a good enough reason, okay? Now, the government said they needed this law to make sure that people could participate in government because the government is run in English in this country, right? So they said if people are going to be able to vote and things like that, they need to know English. And the Supreme Court said that wasn't a good enough reason because learning more languages doesn't hurt that, right? So learning how to speak German doesn't stop your ability to speak English and participate in government. So the Nebraska law was unconstitutional. Similarly, in Pierce versus Society of Sisters, which is a 1925 case, this was a case where there was the Compulsory Education Act in Oregon, okay? And what this said was that if you're between the ages of 8 and 16, you have to go to public school. So it made private school illegal. You had to go to public school. So the Society of Sisters was an Oregon company that had homes for orphans, and they educated people, and they had schools and academies. So it was basically a private religious school. And so the Supreme Court said, does this violate the liberty of parents to decide how to educate their kids, okay? So again, does the government have a good enough reason to say you have to go to public school? And the Supreme Court said the government does not have a good enough reason. This does violate the liberty of parents to decide how to educate their kids, okay? There's no good enough reason to say you can only go to public school. And this has been upheld a bunch of times. This case, though, Pierce versus Society of Sisters, is really the major case that allows homeschooling, right? So you have to let kids go to private schools. You can't, because of this decision and other decisions, mandate public schools. You can say what has to be taught in private schools and homeschooling, right? You're allowed to say things like all students have to be taught math, they have to be taught English, they have to be taught science, right? But the Supreme Court said there's no good enough reason to say it has to be a public school teaching them. Now, the last case from the 1920s is Buck versus Bell, which is a 1927 case. Buck versus Bell is a really horrible case. It's about a woman, Carrie Buck, who they called feeble-minded. And they said that there was a condition that had been in her family for the last 3 generations that made them feeble-minded. In reality, now we know that there's a lot of facts that say that she was just a teenage mother who had a baby while she wasn't married and was sent to a mental institution, as was common for the time. So in Virginia, the law said that anyone who's in an institution could be sterilized to promote the health of the patient and the welfare of society. And before they'd be sterilized, which meant be given a hysterectomy and not be able to have children, right? There was a hearing to decide whether or not the operation was a wise thing to do. And here there was a hearing, and it was decided that the wise thing was to sterilize her, this woman who did not want to be sterilized. So the Supreme Court asked whether or not sterilizing her denied her ability to have her liberty, right? And the court said this law was okay. They said that because there's a hearing, and the patient could be at the hearing and so could a guardian, and that there was appeals courts that could review the hearing, it was okay. It was enough due process. Justice Holmes wrote that the law was good and the state did have enough reason because Virginia had a good reason to prevent the nation, and this is a quote, from being swamped with incompetence, and that 3 generations of imbeciles are enough. So the state did have enough of a reason to sterilize people who they decided were imbeciles. So there was enough of a reason there.